Good morning, everybody. My name is Bruce Broylett, and this is Alan Van Gelder, one of my partners. And we're here today to talk with you about the Olin case that we handled a few years ago, and that is really instructive on some of the things you'd want to know about distracted driving, about how to prove the distraction that was going on, about how to deal with cell phone, texting, and electronic communication matters, and how to reconstruct it all in a way that you can get to punitive damages. So, without further ado, let's go to the first slide. On December 8th of 2013, Milt Olin, who was a 65-year-old, very prominent entertainment lawyer in Beverly Hills. Milt was riding his bicycle. He was an avid bicyclist on a Sunday afternoon, 1 in the afternoon, and going for a long bike ride as he typically did on a Sunday afternoon. Milt had a wife, Louise, and he had adult sons. And Louise, late in the day, when Milt didn't come back, was trying to find out what had happened to Milt. And she comes upon, as she's trying to find Milt, this incident, and realizes that it's her husband, who had been killed when he was struck by a sheriff's deputy vehicle. Louise, of course, was devastated, and I think that Louise, in fact, might be tuning in to our presentation today. And if she is, hi, Louise, how you doing? Louise and I are both Virgos, and that's pertinent to this case a little bit, because when Louise came to us not long after this incident happened, she said she wanted to know every bit of what had happened in this incident. And that even if the other side, the county, had wanted to admit liability, she wanted to know everything that happened that day that led to the death of her husband. Why? Because the sheriff's deputy was trying to say that Milt Olin had cut in front of him, left the bike lane, cut in front of him, and that's why this happened. And Louise knew that that could not possibly be true because she knew her husband. So, fortunately, she was someone who wanted to dig in and find out, as were we. She wasn't going to just settle the case quickly and be done with it. So if you can go to the next page. So the story that was told by Deputy Wood, who was the driver of the sheriff's deputy's vehicle on that Sunday afternoon. By the way, no lights and sirens because there was no emergency that he was engaged in. You can go to the next page. Stories he told was that he had been called out to Calabasas High School earlier that day. You can see Calabasas High School is toward the left of the drawing there, and right next to the football field that you see is a parking lot. And he said he had reported to the high school because of a report of a fire, and that when he did, there was no problem there, and he left. He was finished. So he says he got into his sheriff's vehicle. He waited at the stoplight, he said, to turn left or toward the right on our picture here, to turn left, which is to the right, onto Mulholland Highway. And that he took the long sweeping turn up to Mulholland Highway, and you can see where the area of the collision was. He also said that before he had left the high school, that he had texted his wife because they wanted to look for a baby crib on Craigslist, and they were sharing some information about that. He also said that he didn't remember anything from the time that he left the parking lot up to the point of impact. What he said to the sheriff's deputies who investigated this sheriff's deputy, so you have the sheriff's department investigating the sheriff's department, What he said was, if we can go to the next page, he said, he, meaning Milt Olin, who is now dead, he swerved out in front of me. He also said, he pulled out in front of me, so I kind of went right to avoid him. Then he said, suddenly a bicyclist entered his lane, meaning the deputy's lane, Wood. Suddenly a bicyclist entered Wood's lane of travel from the bicycle lane and rode onto the path of the vehicle. And then in his written statement, he wrote that that the bicyclist had driven into the path of his patrol vehicle. All of that was false. Next slide. He even made a drawing on the sheriff's investigator's report showing him as vehicle number 1 in his lane of travel, and then the bicyclist as vehicle number 2 departing the bike lane and moving in front of the police vehicle, and basically saying it was all the bicyclist's fault. I couldn't avoid anything. And that was all a bunch of malarkey. Next slide, please. Olin was struck in the bike lane. How did we know that? Well, we got an accident reconstructionist out to the scene pretty quickly after the incident happened. Next slide. Just to lay out the roadway for you, there is a travel lane, and then leading up to the incident, up at the top of this little incline, there's a bike lane, and to the right of it, there's a merge lane from the previous street that people might turn onto Mulholland Highway. So you see the bike lane, you see the travel lane, and go ahead, next one. So Daguerre Avenue is the street that people might turn onto to get onto Mulholland Highway at that point. So next. Now you can see the area of impact, and you see that what happens is there's a slight alignment change in the roadway. All of the physical structures on either side of the roadway move just a little bit. Before that, it's a straightaway for 1,000 feet. But you can see that the roadway and the bike lane, everything jogs a little to the left and then straightens out again. And you can see the area of impact was right in that jog area. Next. Pointing out there the area of impact. Next. And here's how our experts were able to figure out that area of impact. These are photographs from the day of the incident taken by the sheriff's deputy. I'm sorry, the sheriff's investigators. You can see the vehicle is still up front over the bicycle. You can see Milt's body, which has been covered at that point by that white cover. And then you see all these little tags here and there, which are tagging places where photographs were taken so that all of this someday could be reconstructed. Next. The way the area of impact was determined was by looking at those photos and also looking at some evidence that had been left behind that could be found by our reconstructionist when he went out there. So you see a scrape mark there that the reconstructionist pointed out in the photos in the bike lane. Next. Then you see he has identified the scrape mark and a little white paint chip right there that he has a measuring device next to. That measuring device and everything was done by the investigators. These photos were done by the investigators from the sheriff's department, and you can see that it pinpoints where impact happened. Because what happened was, when Milt was hit from the rear of his bicycle was pinched. And when it was pinched, it was driven down as his body was thrown backward and he crashed against the windshield. And when it was pressed down, the bicycle was pinched down. It leaves marks, scrapes, paint marks, and so on the roadway. So that's how we were able to prove, number one, that the sheriff's deputy was entering the bicycle lane and hit Milt, who was in the bicycle lane, and not the reverse as the sheriff's deputy was trying to claim. Next. And here we are up close, showing what I was showing before from the police, I'm sorry, the sheriff's deputies, the sheriff's investigators' photos. Next. So what we needed to do was to find out why in the world would this sheriff's deputy on a dry, sunny 1 o'clock in the afternoon, not in an emergency, driving the sheriff's vehicle, why wouldn't he see not only Milt Olin in the bike lane, but the jog in the bike lane up ahead? Why would he plow right straight into Milt Olin? And that's where Alan goes to work.
So thank you, Bruce. So anytime you've got a crash like this, and as Bruce is saying, your alarm bells are going up right away. How does he miss this? So we were already thinking some kind of distraction. So the first thing we want to find out is, what are the potential distractions available to Deputy Wood? And we had a lot to work with to look around. So here's sort of what we had. Inside the sheriff's vehicle, and we'll talk about this in a lot more detail, we had something called a mobile digital computer, or an MDC. It sort of looks like a laptop, and you can see right where it is, and basically the sheriffs are allowed to look up information, send messages. It's a computer, and it's right next to them, and that is a potential powerful type of distraction, which we'll get into in a little bit. In addition, the sheriff's vehicle was equipped with a GPS, and the GPS and the MDC were transmitting both location, speed, and to give us where the vehicle was at any given time, and also what messages are going on. So in addition to the MDC and the vehicle GPS, we also were of the benefit. Milt was an avid cyclist, and he had on a Garmin GPS device, and he was part of he had a program called Strava, or I'm mispronouncing it exactly, but the idea is he was also keeping track of where he was going and what speed he was doing. So we had more data than usual because we had the sheriff's vehicle data and we had Milt's own data. So we can go to the next slide. So, and just to give you an idea of the kind of data we're able to get from the sheriff's vehicle, as you can see here, the sheriff's vehicle is recording every 10 seconds where the vehicle is, and you can see latitude and longitude there. It's giving the speed. This is all stuff that is available and you can get if you happen to have a sheriff's vehicle involved. They have to keep this stuff, and we did request this and we got it, but it shows you what his speeds are. And we've got here highlighted two red arrows here, and I want you to keep these in mind as we go along here for a moment, okay? So you see the first one, 1304 and 2 seconds. It shows he's at 0 miles an hour, 104, and it shows he's at 0 miles an hour. So that is when he's leaving Calabasas High School, okay? And then if you look and you see every 10 seconds, we can see where he's going, what his speed is. Mulholland was a 45 mile an hour speed limit, and you can see at 13:05:03 he's at 48 miles an hour, and then you can see at 13:05:13 there's a sudden drop in that. So you can sort of get the sense, and Bruce will explain this a little more later, about where the accident is. So this is the first data that we've got rolling in here to sort of know what's going on. Can we go to the next slide? And as you can see, once you have those data, you can then start to overlay it onto what we already know from the accident reconstruction. So as you can see where the area of collision is, and we now know at 105:03 at 48 miles an hour, if you look at the lower portion of the screen there, there's a yellow pin put by our accident reconstructionist. So now we know where he was at 48 miles an hour at 105:03, and you can see the two pins. You can see 105:13, he's dropping suddenly to 8 miles an hour, and you can see at 105:23, he's at 0. There isn't a lot of distance between those two yellow pins, showing that there's a pretty sudden stop right in between those two spots. So, and this sort of helps us. So this is our first set of data points we've got. Can we go to the next slide? And so here was the Garmin GPS that was on Milt's computer on his bike. So we not only know how fast that that the sheriff was going, we also know how fast and where Milt was going. Can we go to the next slide? And this is some of the data we were now, it doesn't come out like this exactly on the, when you download the data. Our expert went and, you know, got the data and then created this graphic here. But we were able to show in real time where Milt was. And that's very important when we're trying to show what information was available to the sheriff and when should he have first been able to see Milt if he was paying attention. If we can go to the next slide. All right, so we now know about the MDC. We now know about the GPS. But, you know, look, it's 2013. Everybody has a cell phone, okay? And so what we want to know is, especially when we think we've got a distracted driving situation, is what was Deputy Wood's personal cell phone? Was it in play? The whole 9 yards. Now, interesting point on all of this is that the sheriffs also suspected it as well. And so right after the crash, one of the first things the sheriff investigators did was they got a warrant, and they and Deputy Wood also gave up his gave permission. They got a warrant, and Verizon Wireless provided some cell phone data, and the sheriffs were like, see, the cell phone data proves he wasn't on his cell phone. So here it is, we've got nothing to hide. And let's get into that a little bit. So if we go to the next slide. So this is what showed up. And remember I talked about 1304 was a very important time. So this is what the subpoena that the sheriffs got from Verizon showed. It shows that at 12/8/2013, there was a text message that went out at 1304. And the sheriffs were like, see, at 1304, he's at 0 miles an hour. So his last text was at 0 miles an hour when he was in the parking lot. Therefore, we are ruling that texting and the cell phone were not in play here. Don't worry about it. They didn't say ha ha, but I always imagine that when they turn over such stuff willingly. I imagine they're saying ha ha, you've got no cell phone. But anyways, let's go to the next slide. So we didn't want to take the sheriff's word for it because they were investigating it. We wanted to also subpoena and talk to Verizon. So I want to take a minute and talk about how do you get the cell phone records from a cell phone company. A lot of words. I'm just going to cut to the chase on this. The cell phone companies will not respond to a subpoena, even if you send a subpoena, unless you've got an authorization from your target, and they have a right to do so. They say, I don't care. I don't care what subpoena you got. Without an authorization from your target, I'm not going to produce. Okay, and this is the code section for it. You can look it up. You can download, there's a handout section here. You can download this entire PowerPoint presentation and have all this stuff, because there's going to be a bunch of words that show up in a minute. I'm not going to read all of them. Okay, can we go to the next slide? All right, lots of words. Not going to read the whole thing. This is our standard consent for release form that we send to whatever target we want, and we want them to sign. I won't read the whole thing, but it basically asks for the three things. We want all the voice records, all the data related to voice calls. We want all the records related to text messaging. And if you go to the next slide, and you can look at all this later, and this is your sample thing. You can adjust it as is. So I'm not saying you need to quote this thing exactly, but this is just sort of a template you can use. Anyways, and so here it talks about, and we got the text messages. Can we go to the next slide? Here's something though you don't want to, I want to take a point on. That's item 3. You don't just want the voice, you don't just want the text, you also want to get the data usage. And that's become even more important now than it did back in the at the time of this case, because there are so many forms of communication now that don't rely on text message and voicemail, that are over the internet, that are over mobile, that are using data, WhatsApp. You know, I'm not saying you'd be using Microsoft Teams, but there are so many other web-based apps that aren't going to show up on the records. So sometimes all you're going to be able to get is that the phone was actually firing off mobile data sometimes, okay? Anyways, so if we keep going, so anyways, here's the issue. What if your target won't sign the release? Deputy Wood did sign the release because he thought he had nothing to hide. What happens if you don't, if you run into someone who won't sign the release? So here's the basic thing. CCP 2031.01 says you have the right to anything within possession, custody, and control of the defendant. In this case, the cell phone records are literally under his control because you can't get them without his signature. So you can actually go to the court and you can seek a motion to compel saying, Your Honor, order this schmo to sign the release here because that's the only way we're going to get the records. And so the first part to do that is 2031.010. If we can go to the next slide. Here are some cases. If he goes, you can't make me do this. Well, I'm living in a free country, you know, whatever, take your pick. You're forcing me. No, there is precedent for this. And these are the cases that talk about it. In Negro versus Superior Court, Google didn't want to release some email data because they didn't have an authorization from the target. And so somebody went in, forced the guy to sign a release, and the court said, that's totally fine. You can force a target of a subpoena to sign a release in order to get a service provider, such as a company, to turn it over. And there is precedent for people getting nailed for not signing releases. And that's what the Miranda case is about. Somebody's case got thrown out because he refused to sign a release. So if somebody says, I won't sign a release, and the record target says, I'm not going to give it without a release, go into court, make them sign the release, or get the court to punish the person who won't sign the release. Next slide. All right, so the question is, what is the release supposed to look like? And this is the fight where a lot of people always say, it's private, it's private, it's private. I get it, it's private. We're not asking for every single phone record you've ever had. But at the same time, when you've got facts in a case that say we may be dealing with distracted driving, those privacy rights get put aside. Offer to get a protective order. LA has a stipulated protective order. Most people have them too, a model protective order. Judges love to see that. And but you're going to have to sometimes, if there's going to be a fight, make an offer of proof. So here's what some of the more savvy defendants do. They go, okay, fine. I'll let you have the cell phone records. But you know what? Milt Olin, this didn't happen here. I'm just saying if it did. Milt Olin was killed at about 1:05 p.m. That means I will only let you have cell phone records for 1:04 to 1:05 p.m. No. That's not going to cut it. You want to be able to construct the person's movement throughout the leading up to what's going on. 1:05, you want to know what he was doing before, you want to know what's doing after. You need to push as hard as you can. And some courts, this is where they push back on it. I like to try to get the day or the day before. Some of the arguments for that is I want to know if he had a good night's sleep. I want to know what he was doing the day before for course and scope of employment, what he was doing. I might want to try to go with custom and habit. Is this a guy who habitually talks on the phone while he's driving? That sort of thing. It sort of depends, but you're going to have to actually sort of lay out why you need to do that for your case on that. They're not going to give you weeks and weeks of data unless you can explain what's going on. But these are some of the reasons you want to, and the other thing is you want to look at post-crash too. What did he do right after the crash? And we'll explain why that becomes important later. One of the things that Wood was saying is that, well, the signal in this area isn't so hot. So I want to know how many calls or text messages he made after the crash to show, was this did this area have good signal or not? We can go to the next slide. So we go to even though the sheriffs present us what they got with their warrant, and they show, look, everything is fine. We went and we wanted to subpoena Verizon and hear from them anyways and make Verizon produce anyways, just in case. Now, I will tell you this, by the way, if you have the ability to subpoena the phone records early after the crash, do it, because within a few, depending on the phone company, a lot of data is not preserved. They'll keep the basic stuff, but they can also keep more detailed information if you subpoena them sooner rather than later. In this case, because there had been that warrant, Verizon kept more data than they would than by the time we were able to get our subpoena in. But anyways, Verizon showed up at the deposition, and they brought with them their version of what they had prepared for the county, not what they had given to the county, but how they had prepared their documents, where they got their data from. And we found something very surprising there, and it was a complete, total surprise. And if we can go to the next slide. So don't hit the zoom in yet. So apparently, if you look here, so this is what Verizon brought, okay? And it is a little different than what the subpoena got from the sheriffs. And this was not the sheriff's fault. What had happened was the person on Verizon who had produced the sheriffs, there had been an error on Excel. And what had happened was the Excel had compressed the seconds off of all the text messages that had been given to the sheriffs originally. And so when the Verizon PMK showed up, showed me the documents, well, wait a minute, how come you've got the seconds here? And she explained, oh yeah, there was an Excel error. We didn't have we didn't give the seconds to the sheriffs, but here they are. So now, Jessica, can you blow up what was had? I've got it in red here. So the sheriff's deputies were operating under the assumption that it was 1304 because the 54 seconds had been cut off. And so they said, well, 1304, he was at 0 miles an hour. When the Verizon people showed up and they had the 54 seconds, game change, because 54 seconds is 6 seconds before the crash, and more importantly, Deputy Wood is driving at the time. I remember getting that information going, okay, just one moment, let's take a break. And then I went and I got out of the office, out of the deposition, I went, uh-oh. And then I tried not to do a little happy dance because I had found a little piece of information. I went back in and I said, so you're telling me that this text message was sent at 13:04:54? Absolutely, absolutely. And now we have Deputy Wood texting while driving at high speed. And pay attention to that 13:04:54 because that's going to come really big in this case.
Yeah,
so,
let me just mention something here, Alan.
Yeah.
As you'll see, we determined that the impact was at 13:05:09. In other words, 15 seconds after he pressed send for the text message he had been composing. Now, in a minute, you'll see how we put that all together, but keep in mind, what I said before was that he was on 1,000-foot straightaway. So by having him texting at 4:54 instead of 4:00, we have him writing his text and sending it while he's on the straightaway and should have been able to see Milt. That 54 those were 54 very important seconds. Go ahead, Alan.
And I'm not the most athletic guy in the universe, but when I saw that 54, I would have done a cartwheel if it wouldn't have caused me tremendous injury at the law firm. Anyways, can we go to the next slide? And so, given that, Bruce, go ahead. Why don't you tie what we've got all together here?
All right, there I was already starting to tie it together. Okay, so let's go to the next slide. All right, so remember we have Calabasas High School, the parking lot. We have the left turn onto Mulholland Highway, the curved area, and then he hits the straightaway, which is about 1,000 feet from the point of impact. He would have been on that straightaway for probably 20-25 seconds. I forget the exact number that we came up with or that the expert came up with, but he would have been on there during the time he was composing and sending his text message. Next. Okay, and remember we have the times and speeds and locations. So at 2 seconds after 13:04 or 1:04, he's at 0, so he's back in the parking lot. Then he goes 10 seconds later, he speeded up to 19 miles an hour. Another 10 seconds later, you see he's at 41 miles an hour. At 33 seconds after the 4-minute mark, he's at 44 miles an hour. Speed limit was 45 miles an hour. Take it right up there to 13:04:53. This is just a second before he hits send, right? He hits send at 13:04:54. He's going 40 miles an hour. He hits send, and look, in the next 10 seconds leading up to the impact, 15 seconds later, he actually starts going faster than the speed limit. He's going 48 miles an hour and he's on an incline. Then between 5:03 and 5:13, that 10-second period, he goes from 48 miles an hour to 8 miles an hour. So our expert, based on the physics, the vehicle, the braking rates, and so on, was able to pinpoint the moment of impact at 13:05:09 or 1:05:09 in the afternoon. Okay. All of that becomes very important as we start to piece this back together. Next. So you saw, Alan pointed out to you that when we got the records directly from Verizon, we also got the 54-second period. Next. And so we're able to start laying things down. So at 1:04:53, 53 seconds, a second before he's going to hit the send button, 40 miles an hour. He goes another second when he hits the send button, 1:04:54. And then we have him up there at 1:05:03, 48 miles an hour. What's that? 9 seconds after he hits send? Well, so we're proving that he's on the straightaway while he's texting, and that would have interfered with his vision. But after all, everybody, what about those 15 seconds between the time that he pressed send on his send button on the cell phone and the time of impact? He had plenty of time to see Milt. Why didn't he see him? Next. I'll tell you why. Remember that MDC? Remember the MDC that was in his vehicle that's like an onboard computer? There was no need to be using the MDC because it was not an emergency. No need to be using it while he was driving. If he wanted to use it, he could have just pulled over and done his computing work. It's just like having a laptop sitting there in the car. Next. What we found was this. At 13:04:40, okay, so 1:04 and 40 seconds. By that time, he's already on the long straightaway, but we know he's also texting. At least he's composing his text. He gets the message you see below that says UC4 bro. Next.
By the way, what is C4, Bruce?
Oh, I'm getting there.
Oh, okay. You interrupted me. I get to occasionally do that.
Okay. UC4 bro is one of his compatriots who's checking in to make sure everything is okay, that Deputy Wood doesn't need help on the response he was making to Calabasas High School. That message comes in at 13:04:40. Now, if Deputy Wood, as he tried to claim, was not actually texting at the time when it comes in, if he actually had texted back at the parking lot and it just took forever for the text to transmit because of problems with reception in the area, which Alan will show you turned out to be malarkey, then why didn't he immediately, if he wasn't engaged in texting from 13:04:40 to 13:04:54, why didn't he immediately respond to his friend asking if he needed anything? The reason was he was texting. And what happened was 13:04:54, 15 seconds before the impact, on the straightaway with the bike rider right ahead, he sends his text message, and then, as he says he typically did, he probably put it into his bag and zipped up his bag and used up some time doing that. And then he went to his onboard computer. He was distracted first by the texting and dealing with the cell phone after sending the text, and then he goes to his onboard computer. How do we know that? Because there were pictures of the onboard computer taken at the time of the incident. Notice how the onboard computer screen is leaning forward. It's not up in its normal position. You know why? Because Milt's body, when it crashed into the window, crashed so hard into the window that it hit and pushed down the screen on the MDC. So we were able to pick up what that screen said. Next. Reply to message. What he would do is hit a button and compose a message and then send. And it said to unit 224T2, text, yes, and then gibberish. What had happened was we could prove that he was on his onboard computer in a non-emergency situation, creating danger for anybody around him because of, again, distracted driving. Right after driving distracted with his cell phone and texting with his cell phone, he then goes to his computer. He starts to compose on that, and as Milt's body comes in, it slams down the computer on his hand, and that's why you get yes and then gibberish, as his hand was getting smashed against the keyboard. So we had two instances connected together of driving distracted. Stunning. Next. So we just have this up here to show when that message came in, UC4 Bro came in to Deputy Wood at 10440, and the fact that he took 20 seconds, 25 seconds to finally respond tells you he was doing something else, and he was texting. And that when he says he can't remember what happened between the parking lot and the impact, we all know what happened. Next. And so he comes up the road and he drives directly into Milt Olin. Next. So we had to look at the human factors aspect of that and distracted driving. And we retained an excellent expert from UCLA on this subject. And here's what he explained, and this will resonate with all of you because you know just what I'm going to be talking about. Next. We are single channel processors. Everyone likes to think, or we talk about some people who are multitaskers and so on, and they're just amazing because they can move from one thing to another. But the reality is that every time they move, they are single channel processors. We are not processing multiple things at one time. We're moving from one thing to another and processing and paying attention to that one thing during that period of time. So we've all had the experience of even talking on the cell phone in the car, and you miss your turnoff. Even though there's a big sign there that says, LAX or whatever, you miss it and you went too far. That's because of your attention being on the conversation. And that's single channel processing. So if we can go to the next slide. There was a study done. You can bring up the title. Did you see the unicycling clown, ? Inattentional blindness while walking and talking on a cell phone. So what this was about was they tested some people who were walking and talking on a cell phone to see if they were picking up bizarre stuff that was going on around them. And they had a unicycling clown go into their field of view, and the people didn't even notice it because their attention was on the conversation and the cell phone. So that became a very important aspect of understanding what happened to Milt Olin, because naturally, as you're driving along, you wouldn't expect somebody to take their eyes completely off the road for 21 seconds while texting and then working on an MDC. You would expect typically that they would look up periodically and check out the road as they're doing this other thing that they shouldn't be doing while driving. But the problem is that because the attention is on the texting or the MDC, they don't really see important things in front of them. As our expert explained, they only are able to sort of keep themselves in the lane of travel and generally drive the vehicle along because their attention is elsewhere. So things like a bicycle rider, a pedestrian, or a unicycling clown may not be picked up by their thinking. So next.
And Bruce, before you get
Yep.
to that point, though, what our
Yep.
human factors experts said was that that study was about talking on a cell phone. Texting, the behavior of texting is exponentially worse than just somebody talking on a cell phone because the distraction level is way higher, which is going to tie into what you're talking about next.
Yeah, so we had established clearly that it happened in the bike lane. We had established clearly that the sheriff's deputy had driven straight into the bike lane, didn't make an evasive maneuver, didn't hit the brakes, nothing, just slammed into the back of Milt Olin and killed him. We established pretty clearly that he had been on his cell phone using the text part of the cell phone during the time that he was on the straightaway. We established pretty clearly that then he was on his MDC leading up to the point of the impact after texting on the cell phone. And so how did we get to punitive damages? So we had produced, remember this incident, as I said at the beginning, was on December 8, 2013. Well, we got some news releases from the Los Angeles County Sheriff Department on April 24 of 2013, months before this incident. Next. That news release was announcing Distracted Driving Awareness Month. Next. It said that the Sheriff's Department would be actively ticketing those who are texting while driving. And the deputy admitted he knew about this. Next. Look at what that news release says. Distracted driving is a serious traffic safety concern that puts everyone on the road at risk, including Mr. Olin, Sheriff's Deputy Wood. In recent years, hundreds have been killed and thousands seriously injured in California as a result of collisions that involved at least one driver who was distracted. Deputies are increasingly cracking down on cell phone use and texting. Well, who guards the guards? Who holds the sheriffs accountable? I'll tell you somebody who does, and her name is Louise Olin. Next. Drivers who use handheld devices, and this is how we got it to punitives. Drivers who use handheld devices are 4 times as likely to get into crashes serious enough to injure themselves. Younger, inexperienced drivers under 20 years old have the highest proportion of distraction-related fatal crashes. In addition, studies show that texting while driving can delay a driver's reaction time just as severely as having a blood alcohol content of a legally drunk driver. And at his deposition, the deputy admitted that he was aware that texting while driving was equivalent to driving under the influence.
And you'll see campaigns where they talk about you're driving intoxicated, and there are all sorts of ads and TV things all over the place.
So next. So distraction and vision. Next. Our expert also explained the notion of foveal vision. The way the eye works is there's a little area at the back of the eye just above the optic nerve called the fovea. The fovea is the part of vision that really crisply focuses sharply on something that you're looking at. Everything else is peripheral vision. You've all heard about that. And if you are glancing up, already distracted by an MDC or texting, something like that, and you look up and you don't put that fovea carefully on everything that you're looking at to really scan correctly, all you're getting is peripheral vision, which just doesn't pick up things like a bicyclist, a pedestrian, and so forth. Next.
So and we'll talk about this a little bit, but the texting while driving in this case and driver distraction, look, Louise wanted to know, we wanted to know, we wanted to get the information. But there is another tactical reason for it as well, because the county was gonna admit liability. I mean, he was in the bike lane, he got nailed. And if the county admits liability, you don't get to hear about all the awful things that Deputy Wood is doing. So because there's a punitive damage claim, and you can't bring punitive damages against a government entity, but you can bring punitive damages against an individual, including Deputy Wood. So if punitive damages are in play, you get to still talk about the story and all of the awful conduct of Deputy Wood. So the defense threw up a number of claims to say, no, there wasn't distracted driving, it wasn't distracted driving, and so we're going to go over some of those now. So next slide. So, and now this is a big lesson for people who are lying and people who represent people who are lying, okay? Deputy Wood doesn't want to say he was texting while driving, okay? So his story, even though he was telling the investigators originally, Olin swerved in front of me, by the time he gets the deposition, he can't remember. He has PTSD, whatever it is. He's blocked out that minute of time between Calabasas High School and the collision. All right, well, then that's a problem for them, because if he doesn't remember what happened in that 1 minute, how's he going to deny that he wasn't texting while driving? So Deputy Wood comes up with this declaration where he says, my established custom and habit is not to use my cell phone for any reason, neither a text nor a call while I am driving in my vehicle. And even though I don't remember what happened in that 1 minute between Calabasas High School and the crash, I know I was acting in conformity with my custom and habit that day. So therefore, I am confident there is no way I could have been on my cell phone. So remember, we talked about how important it is to get more than just the 1 minute before the crash when you're getting the cell phone records. You want to get a little bit farther back. So let's go see, did Deputy Wood act in conformance with his custom and habit on the day in question? Can we go to the next slide? Here is that thing again that Verizon produced to us with all the seconds. And Jessica, can you hit the next button? All right, and so we went through, because we have, from the MDC data, we have all the longitude and latitude, which means we know where Deputy Wood was that whole day. So all we have to do is look back on all of the times that show up that day for Deputy Wood's text messaging and see where was he on longitude and latitude. And now, where do you think, Bruce, we were sitting there and I was looking at all of this and we were looking at the latitude and longitude, and guess where Deputy Wood was at 12:34 and 32 seconds, less than an hour before he had killed Milt Olin while he was sending a text to his wife. Next slide. Yep, he was on the 101 freeway traveling 66 miles an hour. And this is death for a number of reasons. Number one, we have now got Deputy Wood lying. Number two, he's on the freeway going 66 miles an hour. And he's on the middle of the 101 freeway. He's not in some canyon where there's a problem with the signal and delay. And we're going to get to that in a second. But this is death. But let's go to the next issue. So the next thing they were going to say is, well, you don't know if Deputy Wood actually was texting while driving. He says the last time he hit a text was before he got on the road when he was at 0 miles an hour in the Calabasas High School parking lot. So our explanation is what must have happened was that area is notorious for having bad signal, and because it's notorious for having bad signal, he probably hit the button and it probably took, you know, a minute or so for the signal to go through. So even though he texted in the parking lot, due to weak signal, he didn't actually, the text didn't go through until he was on the road. So this is an illusion that you've got here that he was texting while driving. So let's talk about that for a minute. Next slide. So first of all, weak signals. Guess what? You can actually go find out what cell phone towers are in the area in question. Look how many cell phone towers are all around Verizon wires. This isn't like we're in the middle of Barstow or some desolate area. There are all sorts of cell phone towers feeding this area. And we got an expert.
If anybody grew up in Barstow, we don't mean to say something negative about Barstow.
I actually should have meant on the way to Barstow. I apologize. That is true. I meant to say on the way in the middle of the desert somewhere. Anyways, keep going. Next slide. So, but, you know, when the defense has to put up something like this, it's a big enough issue. They're making this a tension point in the case. So my expert and I, we went out in question and we had our cell phones and we had our signal trackers, and you've got programs where you can measure signal strength. And we drove the whole thing back and forth. My investigator was driving. My expert was texting in the passenger seat, and I'm recording him. And we're going through, and we go up and down this straightaway looking for the signal. And there was no real problem with the signal. The lowest signal point issue was right after you're on the road outside of Calabasas High School, and even then there was no problem sending text messages and receiving text messages or anything like that. There was no lag, no delay. Now the defense, they brought in their own guy, and he was like, well, yes, that's true, although I was able to create a weak spot for a second, but no, Mr. Van Gelder, you didn't test it on the day in question. Sometimes there is over cell phone demand. What do you mean? Well, if everyone was texting Amazon at the same time or on the phone all at the same time, you could have had a simultaneous lot. So, sir, what you're saying is everyone got on the phone at the exact same time to text some message to someone, and that drove down the signal? Well, it's possible, yes. And, you know, they call these guys in for criminal cases to create reasonable doubt, but here, no. Anyways, if we can go to the next slide.
So the question was, where is Deputy Wood's actual cell phone? Was he really texting his wife? What was he up to? Besides, the cell phone would prove the second that he hit send. And he couldn't very well argue against his own cell phone that the area around him couldn't pick up a signal. So next, as I mentioned at the beginning, Milt was an outstanding, prominent, very well known and very well liked entertainment lawyer in Los Angeles, and a friend of the family before we were involved, and virtually immediately after the incident, sent a preservation letter, evidence preservation letter to the county. Next. It requested the preservation of all kinds of evidence, including all cell phones and mobile devices. The preservation letter is 9 pages long. For some reason, they said that they had only read the first page and didn't read the part about cell phones. That's what they claim. And page 8 even provided instructions and descriptions on how to preserve electronic data. Next.
But by the way, these are all sheriff's deputies. They should know better anyways.
They know.
They're investigating.
They know. I mean, let's put it this way. If one of us was involved in this incident, you don't think they'd be looking at our cell phone? So December 8th, here's the timeline. The bicyclist Milt Olin is killed. December 12th, there's a preservation letter that goes out. On December 16th, a second one. They had 2 bites at the apple. December 18th, the deputy was interviewed by the county's investigators, during which time the investigators looked at his cell phone and then gave it back to him and didn't do any screen captures of anything. On December 23rd, the county acknowledges that it had received the preservation letters. And then in the course of discovery, we asked for them to produce the cell phone, and they said the cell phone was gone.
Well, what was
supposedly at his deposition, he testified that sometime in February, he was packing up their car and he had leaned the cell phone on the top of the hatch area and had forgotten it there, just sitting in that little ridge where the bushing is when you close the rear hatch. And he says he closed the rear hatch and he crunched it. And so we asked him, well, did you try to download some information from it? No. Did you take it over to the company to ask them if they could download some information from it? No. Did you give it to the county so the county could try it? No. So he said he accidentally destroyed his cell phone after preservation letters had gone out to the county. So we thought, let's depose his wife and get her cell phone, and we'll see what those messages were and what time they came in and so on. And next, the wife said her phone is gone too. She may have given it to her daughter, who knows, but she doesn't know where that phone is. And so both ends of the text messaging were gone in the face of 2 preservation letters to the county. Next.
So again, if you're the county, you're in trouble here. And I have to give the county lawyers credit. They tried very valiantly to come up with every possible excuse, defense. You know, I'm going to give the county lawyers credits. They threw everything they could at this. And so don't think that this was an easy time of it at all. So the next excuse was, well, okay, the cell phone was lost, destroyed, whatever. But does it really matter? It's not like you would have found anything on that cell phone. But see, this is the problem when you start coming up with things like the weak cell phone signal defense, because it turns out you actually can figure out when a cell phone actually sends its message versus when it actually goes out onto the network. And I don't want to get too technical, but let me just show you briefly. He had a Samsung Galaxy S3 phone. So let's go to the next slide. So what we did was, since Deputy Wood's cell phone doesn't exist anymore, we had to go out and get a Galaxy Samsung 3 phone. So there it is. And what we would do is we have the sample phone over there. We got it on the Verizon network. We set it up. And what we would do is we would send messages, our expert would, between the Galaxy phone and the sample phone. Okay. And if we go to the next slide. All right. So there is something, if you're a paranoid lunatic about people spying on you, there is something called a Faraday bag. And what a Faraday bag does is you put the cell phone in the Faraday bag. The Faraday bag will cut off all signal from the phone. Even if the phone, no matter how hard it tries, the phone cannot pierce the Faraday bag, the signal. So what happened was, what we did was we put the phone in the Faraday bag, and we started texting on the phone in the Faraday bag. So there would be no signal while we are texting. And then we take the phone out of the Faraday bag, and as soon as the phone is out of the Faraday bag, it can connect to the network, and then the text message goes through. So we are trying here to recreate the BS excuse offered by Wood. I sent the text, there was bad signal, and it connected later. So the question, though, is how can you show whether or not something was going on here? So if we go to the next slide, and this is a lot of stuff, but there's a program, it's called Celebrite. We had our cell phone expert go and download, so we had our sample phone where we did it in the Faraday bag and then connected to the network. And the Celebrite was able to capture the time that the draft message was created versus the time that it actually connected to the network. So if we had the phone and we put it through Celebrite, we would have been able to determine when that actual message was being typed out, and then we could test the theory of whether or not there was a weak signal. So again, destroying the phone is bad enough, but then when you try to make weak signal your defense, you are actually putting at issue the destruction of the phone. And look, we're lawyers, we do good work. I acknowledge that. The jury is going to be like, wait, the sheriff's department couldn't do this? This is just bad, bad stuff. Can we go to the next slide? So after that, and I'm going to hand it to Bruce in a second. So now they're like, okay, well, okay, but it wouldn't have made a difference. The texting while driving didn't make a difference. And then they hired an accident reconstructionist out of Utah. And Bruce, you can talk about that.
Yeah, so what they wanted to do was to say, look, even if he was texting, if he hadn't been texting, he couldn't have seen the bicyclist anyway. Even if he was on his MDC, if he hadn't been, he couldn't have seen the bicyclist anyway. So here's what they did with that. Next. They got the information about the kind of clothing, the colors and so on that was being worn by Milt that day and the kind of bicycle that he had. Next. They then showed 16 seconds before impact with a photograph how far away Milt would have been. I mean, if you look at the photograph, you can't see him at all. Now, have you ever noticed it with your own eyes? You can be at the farthest end of the football stadium, up at in the highest, furthest end zone seat that there is. And when the goal line stand is going on at the other end of the field, your eye can telescope and focus on what's going on all the way at the other end of the field, hundreds, well, a couple hundred yards away, right? You do that because that's the way the eye works. So it's not fair to be using a photograph like this, a still photograph, to say this is what the human eye would actually have seen 16 seconds before impact when he was done texting and was moving over to the MDC. Next. This is getting closer. There is De Geer Road on the right, and then we come into the last little stretch before Milt was struck, before the jog in the bike path and the road. And if you look at that photo, you can't really see Milt because of the background behind him. If you really try hard, you might be able to pick him out. But by that point, your telescoping abilities are going to be even better 8 seconds before the impact. Next. Now there you can see zooming in 8 seconds before the impact. And the argument they wanted to make there was, look at how he blends into the background of the trees and stumps and so on that are there. Next. Now you see 4 seconds before impact without telescoping. And again, we all can see him there, but what they're saying is he doesn't jump out at you because of the kind of clothing he was wearing. Next. And they're zooming it in 4 seconds before impact. More observable, but still kind of hard to see. A little harder to see than if he was wearing white. And then 2 seconds before impact, and next. Okay, go back one, if you will. One of the big problems that our experts explained with this kind of visual reconstruction is that a camera is not the way the human eye works. The human eye, foveal vision, focuses on particular things and really zeroes in on them. But there's another problem with using photographs like this in this particular case, and that is that motion attracts attention. So if you see the bicyclist, they have him in a still shot. But if it was actually live, his feet and legs would be pumping. And that kind of motion is something that attracts attention, deals with background that may match the bicyclist, and draws attention to the bicyclist. And therefore, what they were trying to do here to say, hey, none of this mattered anyway, he was hard to see, was just a bunch of malarkey. Next.
Well, before we get to that, for 1 second, during the deposition, Bruce asked the expert, hey, did you do a video recreation of all of this? No, I just took still photos. I didn't think a video recreation would have been necessary or helpful. Other small pro tip, there had been a small change to the road after the incident, and the expert actually had to go out a second time because the judge threw out his first reconstruction because there had been an alteration to the road that made it not representative of what was going on. So if you're going to do one of these studies, make sure you get it to match the conditions in question, or it might not come in.
And
Anyway,
by the way, that was the defense expert
yeah,
that Alan was talking about.
correct. Yeah. So anyways, all right. So we've now sort of laid out the story here for a moment. So the question is then, they want to admit liability. They think that if they admit liability, they'll be able to hold down the verdict because they're going to take out all of the awful stuff that happened. And more importantly, Deputy Wood and his, how shall we say, truth-averse nature doesn't ever enter the courtroom. So then the battle becomes punitive damages. We moved to amend to do punitive damages. They fought that. They then filed a motion for summary adjudication. We then fought that. Then they filed about 6 or 7 motions in limine designed to fight that. Then they moved to trifurcate the case to fight that. So they knew they were in trouble if punitive damages get in front of the jury. So we over and over and over again, motion after motion after motion, and they lost every single one of them. But I'm going to now tell you about how we got to punitive damages. And look, punitive damages are designed to punish horrible conduct here. But my Lord, do they set up roadblocks here to try to get people not to be able to do punitive damages. And there are a lot of judges who don't get how punitive damages work. And there's a lot of bad decisional law out there. So how did we get this case into punitive damages? So let's go to the next slide. So here's the basic statute. It's punitive damages, the defendant, oppression, fraud, malice. Those are the key words. And there's a case, it's called Taylor versus Superior Court. It basically says that the defendant was aware of the probable dangerous consequences of his conduct and that he willfully, deliberately avoided. Now, Taylor is an important case. In Taylor, punitive damages were applied to an individual who was driving while drunk. And this guy had a habit of driving while drunk and knew driving while drunk was a big, bad deal. And remember how we had talked about this earlier, is that texting while driving, driving while distracted, makes you as dangerous as a drunk driver. So that is the first sort of entry point into this, that we have to educate the judges. We had several of them. They all got it. They were all great. But we had to educate them that, look, texting, distracted driving is the same thing as driving drunk. Once you understand that point, it gets a lot easier to get into the realm of punitive damages for us. Because if you say driving while drunk, well, yeah. Now, the defense's big point, and we'll get into this for a moment, is, well, Taylor was decided before there were changes to the punitive damages law, and it made no mention to despicable conduct. And we're going to get into that in a second. But I'm sorry, if you are loading up on alcohol and then you get behind the wheel, that's despicable conduct. And it's hard to sort of defend that. But anyways, let's keep going. So, and here's Taylor, and you can read the thing. I'm not going to read it now, but these are some great quotes from Taylor about how driving while drunk, because a lot of people are operating under the misconception that punitive damages only applies to intentional conduct. I have to assault the person. I have to kick the person. I have to do something with intent to cause harm. That is not the case. The big phrase here is conscious disregard of safety. Even if you're not looking to kill someone, even if you're not a mustache twirling axe murderer, if you are acting in conscious disregard, you are in the realm of punitive damages. But they go, Taylor's an old case, it's old, you can't do that. Let's go to the next slide. All right, fine, I'll give you a newer case. This is Pfeiffer versus John Crane, and here's the citation for it. This is an asbestos case. The company was not looking to poison its customers with asbestos shaving. They didn't sit in a room and go, ha, 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 let's wipe out some of our customers. No, but what they knew is they knew about OSHA regulations protecting its own workers about it. They knew about the dangers of asbestos. They didn't issue any warnings until the 80s, and they knew their products were generating dust. And they only warned customers if the customer said, hey, should we be worried about asbestos? And so the court in Pfeiffer says, look, the evidence established that the defendant, JCI, carried on despicable conduct with an awareness of the probable dangerous conducts and willfully failed to avoid them. So anytime a defense attorney tells you, oh, well, it has to be despicable and you can only do it if you intended to kill. No, look at the Pfeiffer case. Cases just like that. If you know and you don't act, that is conscious disregard. That is punitive damages. Next slide. So this was a case that came up specific to our case because I don't want everybody here going, well, if I've got texting while driving, congratulations, woohoo, I've got punitive damages. There are some judges who are not going to say texting while driving in and of itself is enough. That is why we went through this whole thing. First of all, our punitive damages claim wasn't just texting while driving. It was distracted driving. All of the things he was doing to be distracted. But here's the point. There's this case from 1980. It's called Dawes versus Superior Court, where the court is sitting there sort of waxing poetically, and they go, well, just because you're driving while drunk doesn't automatically mean punitive damages. We need to hear a little more. What were you doing? And, and they say, well, look, this guy was zigzagging all over the place, in and out of traffic on an afternoon in an area he knew it was crowded. So, yeah, I'm all for punitive damages on drunk driving. But the defense wanted to glom onto this idea that texting while driving isn't enough. Remember, and the other thing they'll say is it's not in the slides, is they'll say, look, how bad is texting while driving really? If it was a really serious thing, you'd go to jail for it. You only get an infraction. I forget, it's like a $25, $50 fine, whatever it is. If texting while driving was despicable enough to be punitive damages, then they would give you a higher penalty for it. And I got to tell you, I think they need to improve the laws on this. And that's one of the things that Louise has been pushing for, and other people all over the country, is improving of the laws, is because I do think if you're texting while driving, the penalties need to be bigger. Anyways, so if we go to the next slide. So anyways, we get to this point in the courtroom, and the defense is like, look, this isn't a big deal. He was texting while driving, 15 seconds before. He was on the MDC, and the MDC he's legally allowed to drive on. Yeah, but he's not allowed to text in a non-emergency. So anyways, how big of a deal is this? So I got up in front of the judge and I said, look, we've got 15 seconds of distracted driving. And I said, Your Honor, I apologize for what I'm about to do, but I'm going to turn my back to you. And let's count how long 15 seconds is, because he's not registering what's on the road. That's virtually driving blind. And I counted out 15 seconds. 1, 1,000, 2, 1,000, 3, 1,000, 4, 1,000, 5, 1,000, 6, 1,000, 7, 1,000, 8, 1,000, 9, 1,000, 10, 1,000, 11, 1,000, 12, 1,000, 13, 1,000, 14, 1,000, 15, 1,000. And my point to the court was, I said, look, maybe in the first second or two, he's not thinking about the consequences of it. But by the time he's texting at 15 seconds, he knows that he is putting the public in danger. 15 seconds is conscious disregard. And we would admit, as he had to, that he knew texting while driving was dangerous. He knew it was the equivalent of drunk driving. It's not like he didn't think this was some innocent act. And the longer he's distracted, the longer, the more malicious it becomes. And then we pointed out he also lied. He destroyed his phone. He had a custom and practice of texting while driving. He's a public menace. He's a lying sack of excrement, the whole 9 yards. I was a little more polite about it. But anyways, all of those things together, that's punitive damages. And court after court after court said, yep, that's punitive damages. It was a one-lane road, Mulholland Highway. It wasn't like, and he knew there was a bike lane right next to it. It said bike lane there. He knew he was driving next to a bike lane in an area frequented by bike riders. He knew he was driving at 45 miles an hour, practically freeway speed. I tied it back into Dawes. Look at all the things he knows he's doing, as every second he's off the road, texting, MDCing, the more that, if you think about it, sort of the graph line, the malice goes up and up and up. So with all that, that's sort of how you tie in the punitive damages, and that's how we got to the jury on the question of punitive damages. Next slide. So again, I got to give the defense credit. Again, they know they're in a lot of trouble, so they're throwing everything at the wall. So we now need to talk about how crazy California law is with respect to punitive damages for a moment. You can only bring punitive damages claims in a wrongful death case if you have what's called a survival action. What does that mean? You have to have the estate as a plaintiff. It is not enough to have the relatives as a plaintiff. You need to have the estate of Milt Olin there, because the relatives under California law in a wrongful death case, and I strongly disagree with this, but under California law, the relatives are not allowed to seek punitive damages. Only the estate of the decedent can seek punitive damages. But it gets stranger and dumber. Let's move to the next slide. So it's in order to claim punitive damages, you have to show that your client survived for a period of time. If the person is instantly killed, there is law out there that says no punitive damages. It is insane. I can spend a whole thing explaining why that's wrong, but that's what the state of the law is. So, and it used to be, it's like, okay, look, if the person gets injured, he's in the hospital for a few hours or a few days, and he dies in the hospital, he doesn't lose his claim, he can seek punitive damages. So then it became, well, you know, maybe there's instantaneous death. So here are the authorities you need to pay attention to on this. It's Stencil versus Aero Engineering Corp. and Grimshaw versus Ford. Basically, they stand for the proposition, an interval of time, however brief, elapses between injury to victim or to his or her property and death. If you can show the interval of time, however brief, you get to punitive damages. So what did the defense do? The defense hired a biomechanic expert, and basically they said, okay, Deputy Wood's vehicle smashes into Olin. Olin goes over the hood of the vehicle, smashes hard into the windshield, and they said that instantly killed him. And so think about how horrible this defense is. We did such a thorough and complete job of killing Milt Olin, and we did it so quickly, we should not be punished for it. Can you imagine arguing that to a jury? I don't think they're going to, but they want to keep this out of the jury at all costs. So this is the pitch they're making to the court. We instantaneously killed Milt, we should be rewarded for it. Don't let us be suffered punitive damages. So, but again, this is the problem. County coroner, this is the county's own coroner, deposed the county coroner. And I said, hey, did Milt Olin instantly die? No, he did not instantly die. Well, how do you know that? Well, because I looked at his lungs, and this is horrible stuff, but this is when the defense has to make this an issue, we have to fight it. So what does the coroner say? No, he didn't instantly die because there was blood in his lungs, which tells me he breathed in some of his own blood, which meant he was alive long enough to breathe in his own blood. On top of that, she says, I don't really even believe in the concept of instant death. Short of the Death Star disintegrating a planet, I don't imagine anything is instantaneous death. On top of that, but we have to go through an interval of time, however brief. Well, Milt was not the first thing injured that day. It was Milt's bike. Milt's bike was wrecked before Milt was by 1/10 of a second, but Milt's bike was wrecked first. He had a property damage claim a split second before his wrongful death claim. And so we said, hey, the bike was damaged too. In Stencil, the same thing was used, and there a pocket watch was damaged right before the person was died by a split second. And they said that's enough to get you to punitive damages. And then finally, as Bruce is deposing the biomechanic expert, he's like, okay, walk me through your instantaneous death analysis. Well, first he comes over the big bars and his leg gets smashed and cut and pierced. So Bruce is like, so before he gets smashed into the windshield, he already has physical injury claims? Yes, he already has physical injury claims in that 1/10 of a second that would have potentially required hospitalization. So all of those things together take care of the survival claim. But my point is, pay attention.
Yeah, let me add something to that last little point. So when I deposed this fellow, he said that when Milt was hit, that there was a gouge or a large cut or something in his leg from the bars on the front of the vehicle, of the police vehicle, and that it gouged him. And so then what I did, recognizing that in an estate case, you can't have damages for pain and suffering, that dies with the person. You've got to have some economic loss. So I then asked him, okay, so when was that gouge such that it would require medical care? And he said yes. And I said, and therefore, at the moment before he died, after being impacted, no matter how brief, he had a potential claim for the cost of medical care, right? And he said yes. So I don't know that we necessarily needed that, but if you add that in there, that the estate had a claim at the time of death related to the incident, that may help you get over on this point.
Right. Okay, next slide. And Bruce?
Okay, so I've mentioned that Louise Olin has been a warrior on this subject on behalf of her husband. She has worked so hard to make sure that what happened to Milt did not happen in vain and doesn't happen to other people. So I'll show you just a few pictures. Next. So that's Milt. Next. There he was in military times back during the Vietnam years. Next. There he is, growing his hair out, playing a little guitar. I call that COVID hair these days, where it gets a little longer because people aren't going to the barber shop as much.
Speak for yourself.
There he is with Louise when they were first dating. Good looking couple, obviously. Next. There he is with one of their kids at what looks like a Dodger game. Next. In the pool, I mentioned they had 2 kids. Next. Out there in the beauty of America that we all know about with the family. Next. Beautiful picture of the 2 of them together taken in 2010. Next. The bike rider, always with his helmet on, just like he was that day. Next. Very respected lawyer speaking on a panel having to do with entertainment law issues. Next. So when this happened, if you go to the next photograph, you can see the loss that these people had, that Louise and the boys had. Next. Here he is with some of his pals. Next. Speaking at a panel again. Next. So that is a bike that was painted white, and his name was put on it, and it became a memorial at the site where he was killed on the highway there. And people would come up and lay down flowers and wreaths and everything in honor of this very fine man who had been run down like this insensibly, terribly, and had left behind a beautiful wife and 2 wonderful kids and grandkids. And so what she has done, and you know, they always say that it isn't about the money. You know, the money forces them to pay for what they did. The money changes conduct. In this case, the Sheriff's Department changed some of its policies regarding this subject matter, as we believe, as a result of this case. But she also established the Milt Olin Foundation, where she is working hard and has been since this incident happened to try to prevent this sort of thing happening to other bicyclists, happening to other people and named after her husband. And that's the commitment that she has. And because of her commitment, all of what we've been talking about was uncovered. Changes have been made. The foundation is working hard to bring about change, to bring about benefits to society. So just remember that the cases we're involved in sometimes make a difference far beyond the case itself. So here we are.
So I'm looking here for some questions here for a moment. And let me, and you can type in some questions here for a moment, but I am going to take some of the questions that I'm seeing here. The first question we've got is, what was the economic damage? How did you go about proving all of that? And so Milt was an entertainment attorney. And so what we did was we deposed, Milt's partner. We also produced earnings. We also sort of got a survey of the industry, got some expertise on that to sort of help explain what the earnings picture looked like that as well. And, there was the defense tried to then say, well, maybe the person didn't have a certain amount of, how it's speculative to do that. So what you do is you open up, they tried to say that, well, maybe he wouldn't have, it's speculative. But when you put people from the industry who worked with him saying he was a leader in the industry and that everyone loved Milt and all of his clients and things like that, that was very helpful in dealing with all of that. We had a question about what's the name of our human.
Hold up a second. So one feature of the loss of earnings picture, loss of support, because he was 65 years old, is how much longer is he going to work? So one of the principles that we established, and there were actually some state bar statistics on this, is that lawyers and professionals generally tend to work beyond what people would consider a normal working age for retirement. And the defining characteristics for that are that the person, number one, loves what they do, number two, enjoys what they do, and number three, are successful and respected in the community about what they do. And the more of those features that are there, the longer the person is liable to work. Well into their 70s, even into their 80s. And we all know lawyers that are like that. So in Milt's case, we were able to project out a longer work-life expectancy because he met all those criteria, and we had a lot of people that were prepared to come in if the case had not settled and to testify about how he had all those characteristics, and then the jury could reach their own conclusions on that.
Right, and the county had their own expert to try to say no, that the numbers were lower. But one of the things was that they were including lawyers who were not satisfied with their work. One thing we found was that lawyers who were successful and who were satisfied in their work, their statistics went way through the roof. So yes, there are some lawyers who burn out, and those lawyers burn out are not happy, they retire earlier. That evidence did not exist in our case. So let me roll through some questions here for a moment. First, did the county fight production of all texting data and MDC data? No, they did not. We threatened a court order. They produced everything. Next, does the MDC have internal GPS that tracks location and speed? Yes. The MDC is tied into the car. It's all together. If they have the MDC, they have the GPS, the speed, it's all together. So the sheriff's cars, if they're fitted with that, you will be able to get all of that data. I can't speak to every single department, but if they've got a setup similar to what the county has, they are supposed to have the GPS data, the internal speed, all of it. And it's all tied into the MDC. One thing to keep in mind, one thing that almost terrified me at one point is make sure you understand the syncing of the times on all of those, because the phone company uses one type of time. I think they use GMT time. And you have to get somebody to lay the foundation to explain that the MDC time is synced to the Navy master clock, things like that. Let's see here, what else? What was the name of our human factors expert from UCLA? His name is Dr. Phil Kelman. There was a question about the cut being beneficial for helpful in showing keeping punitive damages alive. The point that Bruce was making on that was that if there was an injury that existed before death, the argument is that means he had a cause of action for an injury and that predated his death. Therefore, the survival action was intact. You take that with the damage to the bike, you take that to the damage to all the other items, and you have a survival item together here. Hold on.
And by the way, the medical bills would have survived his death. So if he would have been hurt with pain and suffering because of it, but then he died, the pain and suffering would not survive with the estate. But by establishing that he would have been incurring medical bills to deal with that cut had he survived the incident, then we had the economic loss, which does survive the death and go to the estate.
There's a question here. Who was the expert who downloaded the MDC data? It was downloaded together. It was an observed download. I can't remember if our expert downloaded it or just observed it, but our expert in all of that field, that came from Ponderosa Accident Reconstruction. They operate out of Colorado. Bob Caldwell and his group, they were our people that were involved in the MDC downloading process, making sure all the data was there and where it had to be. Let's see here for a second. Another question is, did we do a focus group? The answer to that question, and I know I'm going to answer it, is that yes, in this case, we did do a focus group. Bruce never likes to answer it, but I do like to answer it. So the question that follows is, what did we learn about the focus group? Well, first of all, we learned a couple things. Remember we walked you through that whole scenario about the loss of the phone? We had a focus group and we picked a pretty conservative focus group. And I got to tell you, as Bruce was building up to the moment of the lost cell phone, and so then where was the cell phone? The focus group jurors were actually starting, sort of like when you're in a movie and you hear a horror movie and you hear, don't go into the shed, don't go into the shed. You could hear the focus group jurors going, oh no, oh no, oh no. And then he goes, and Deputy Wood destroyed his phone. No. And then Bruce said, and I will never forget this. And Bruce said, well, we wanted to see, did the wife have, oh no, she didn't. There were several of them. They were just, and we're talking like, and that juror who screamed that was a conservative juror from Van Nuys. And they were just, and I got to tell you, well, what kind of jurors do you look for in a case like this? I got to tell you, liberal jurors, conservative jurors, they all hate texting while driving. They all hate people who destroy evidence. They all hate that kind of stuff. So this plays, your Trump supporter, Biden supporter, doesn't matter. Everybody hates this kind of conduct, which is why the defense was so desperate to try to keep all of that out. We have a question here. How much did we ask the jury for in closing and punitive damages were awarded? On the eve of trial, the case settled before we got to the jury. So the number you've got there is what the county voluntarily paid in order to resolve the case. I believe at the time it was either the largest or one of the largest voluntary county payouts involving a non-shooting case, as I recall. At the time, and they had to go through a press conference for all that. And what's great about this is it's public record, which means everyone across the country sees if you've got a distracted driving, that's $12 million right then and there.
Now let me make a little point here, Alan. Remember, the punitives would only lie against the deputy.
Correct.
So it isn't like you're going to be able to put up some gigantic number, because it depends on the financial condition of the deputy or the individual that you have brought the punitive damages against. Punitives do not lie against a government entity.
Let's see here for a second. Let me see here. What other questions do we have here for a second? I am looking here for a moment. The other thing that I was going to say, minor nuts and bolts here for a moment, the bike was in possession of the sheriffs. We got the bike back. Obviously, the bike has evidence on it that you want that helps put together. That's how you can get the scrapes and the gouges, the helmet, things like that. All the little things that come together that you need for something along this thing. And one of the things is there was a question here, did they win the bifurcation motion? It was a trifurcation motion. The answer is no, the court denied the trifurcation motion. What they wanted to do for trifurcation was they wanted to first wanted to try the issue of, and I'm trying to remember what it was, they wanted to try first the damages phase. So they wanted to do first, what were the damages? Then they wanted to do, was there malicious conduct? And then what were the punitive damages? So that's what they wanted to do on the trifurcation motion. The court was like, no, rightfully so. Let me see here, what else? Wait just a second, I got a couple more questions here, hold on. Just have to get this window to work here for a moment. The other question that was had, I'm trying to think here for a second. I think I covered that question. Wait, there was one of the things you hear all the time in these cases are, come on, this is a momentary distraction. This is what the defense argued. This could be no different than someone who looks to turn their dial on the radio or sees a fancy billboard somewhere. It's a momentary distraction. And that's not malicious conduct. That's why it's important on these cases, not just to go texting while driving, punitive damage is over. You want to draw out how long the distraction is, where, what, how, so that the court really gets the idea that this is despicable, ugly conduct. So, Bruce, is there anything you want to add? I think we are out of questions.
We've used our time up, and thank you all very much for being here. You can get the various cases and language by looking at the PowerPoint, stuff that Alan was talking about on some of the legal issues. And thank you all very much. If anybody has any other questions, feel free to give us a call at the office, and we'll be happy to discuss the issue with you.
Or shoot us an email. It's at the end of the PowerPoint. So.
All right. Thanks so much. Have a great day.